what they would lose versus what they will gain, because most people would have a lot of investments, which most people don't. And it keeps, they have skin in the game now, and even if it's $1,000 or $5,000, whatever the small amount is.
And I think, look, I think that that's a
Keeps them in the
perfectly
game.
acceptable business practice, but it's just something that both of the parties have to agree to. And if they're truly confident that they're rock solid, there's no reason that they should hesitate to either waive that financing contingency or have the earnest money go hard.
Well,
Scott, can I
lawyers
inter-
always
this is a good
investigate on the
stat.
first date.
What's that, Don?
They're always
All right,
Go ahead, go ahead.
So this is a good stat. So we're texting each other back and forth over here in this corner. We went to a very prominent escrow officer. How often are loan docs there 3 days prior to close of escrow? You guys want to hear the percentage? 5%.
I wanted to say 10.
5%.
Okay.
How many CDs are signed 3 days before?
CDs.
The ones
Closing
that
disclosure.
have that they have.
Oh, closing documents.
Yes,
Yeah. Now,
those are signed. Oh, no.
No, they are.
They are
do
signed.
the buyer and the seller both sign 3 days prior?
No, not buyer and seller, that the buyer has gotten their
Yeah, and signed.
disclosure.
And that
3
satisfies,
days
look, and
before.
that's one of the 3 options under Section 2B, right? So that's an option.
That's an option.
But is there anything wrong with issuing a cure notice? No, okay? In fact, I think when you're doing that, you're protecting your client's interests, and it doesn't have to be conveyed in any sort of hostile or negative way. All right, you can pick up the phone, you can make a phone call, you can explain to them why you're doing it, and you can do it in the nicest of ways, but you're still protecting your client's interests. All right? All right, let's talk about seller concessions. Seller concessions is my least favorite section of the entire purchase contract. All right? I think that there is no section in the purchase contract that is abused more than seller concessions or misinterpreted. All right? So what we tried to do in regard to seller concessions was we tried to rein in the language and make it clear that, hey, seller concessions, loan costs, impounds, and escrow costs. That's it. That's what constitutes a seller concession. I'll tell you about one that we saw not that long ago. Buyers were flying in from California to sign the loan documents. The airfare was listed as a loan cost. Not a loan cost, okay? One of the changes is that we eliminated prepaids, and we tried to make it clear that, look, the seller's agreeing to pay up to a certain percentage of the purchase price or up to a certain dollar amount. If you put in $2,500 and the legitimate closing costs or the legitimate seller concessions are $2,000, how much do they have to pay? $2,000, right? And we're seeing, and it's becoming kind of a norm, is that people are just trying to milk that additional $500, okay? And they're doing it a lot by prepaid, saying, well, just go ahead and pay the next 2 months in advance of the HOA dues. That's not what we're intending for seller concessions. If you want to do that, that's fine, but you've got to put it in the contract on Section 8A so it's agreed upon by the parties. Otherwise, you're agreeing to pay up to a certain amount, and we're asking that you try to keep those seller concessions legitimate. Fair enough?
Can you define impounds versus prepaids then?
I would say, look, an impound is what's necessary for the loan. The prepaid, and there may be instances where prepaids are required, and that's fine. That's when they become a loan cost. But when they're not required, then it's not a seller concession. Good? Okay. Appraisal costs. Let's go to Section 2M. This is another section of the purchase contract that I think had some ambiguity, and the ambiguity is this. The seller agrees to pay for the appraisal. When are they paying for it?
Upfront.
Some say upfront, some say close of escrow. It was never really clear in the purchase contract, okay? And I think that this is one of those areas where we had the ability to clarify the language to remove any dispute. And so now, the money is due when it is required by the lender. When the lender asks for it, that's when you're writing the check. Most of the time, that's going to be before close of escrow. It may be at close of escrow, but most of the time, it's going to be before close of escrow. And we're also making it clear that, hey, you give that money up front, it's non-refundable, okay? Because that wasn't clear either. And so we had sellers that were paying for it, then the deal fell through and they wanted the appraisal money back. That's not how it works, okay? Once you give that money and you pay that fee, you're not getting it back. So you represent the sellers. You need to make sure that your sellers understand, okay, you want to pay, you're agreeing to pay for the appraisal, realize you're probably going to be paying for it up front, and if the deal doesn't close, you're not getting the earnest money back. So we tried to clarify that language, again, because we're seeing a lot of disputes as to the timing of the earnest money and then what happens when the deal doesn't close. Make sense to everybody?
Yeah.
Okay. Seller's property disclosure statement. Seller, go ahead, Sandy.
Sorry.
Yep, no problem.
There's one section you skipped in.
Go ahead.
And I've had this situation
Yeah.
3 times in the last month.
Yeah, which section?
And it's line number 120 to 122. And it says the new change is if buyer is married and intends to take title as his or whole separate property,
Mhm.
a disclaimer deed may be required.
Correct.
So I was on those committees.
Sure.
And the idea was that husband has bad credit, the wife has good credit, and so on. The problems I've had with you guys, not with you guys, but we've experienced is, wife is buying it by herself,
Mhm.
they're separated.
That's it. That's the exact example.
And
They're
this says it
separated.
may be required, so it's really more of a disclosure than a requirement.
Right, because here's the thing, we want the buyer to know, hey, your spouse is going to have to sign this, and we want them to know that up front, not at the closing table, and all of a sudden the deal falls apart because the other spouse who they're separated from, but they're still married, is refusing to sign. And so we just wanted to make that disclosure so they knew early on in the process, hey, that's fine, you wanna buy it as your sole and separate property, that's okay, but your spouse is probably gonna be required to sign a disclaimer deed.
So it's up to us to find out if it's required by the lender or whomever.
I think you asked the question, sure.
And if it is, then do we cure them? I mean, how do you enforce it?
No, they have to have a spouse that's agreeing to sign. I mean, otherwise, they shouldn't be moving forward with the purchase contract. But yes, if that spouse doesn't sign, you're curing, and chances are, the seller's gonna get that earnest money.
And there's no
because the
time
buyer
limit
can't
on-
perform.
and there's no time frame when the spouse is supposed to sign, so this can go all the way to closing.
In theory, it can, that's right.
I mean, it's just very
But
ambiguous.
but again, that's one of the reasons we want them to know upfront, as opposed to, because a lot of times they're learning about this requirement at the closing table, when it's too late. And so we wanted to put the information in there. But what can you really do to require it up front?
That's my question.
And that's the
Yeah,
problem.
Yeah.
And that's the issue. Go
Well,
ahead.
if you find out about it, put the disclaimer in your counteroffer, and by signing this, you're well aware, or put the disclaimer deed as an addendum.
Okay, so let me ask you, do you know, can you require the disclaimer deed to be signed at the beginning of the transaction?
Why not?
I guess if you get it prepared and you wanna make it contingent on getting that signed document, you can do it, all right?
I mean, as long
That-
as
if
you're
you're really that concerned about it, that's an approach.
Well, as long as your seller's on board, right? I mean,
Yeah.
you have to make sure that you just don't go rogue.
Correct, correct. Right.
No, because the longer you're in the business, you have a tendency to do that. Well, nobody would do that, I'm just gonna make the decision. No. You wanna make sure your seller's on board, because what if the deal is ruined by that, right?
And they gotta use it.
And then he's talking to a buddy and said, your listing agent did that, we probably blew the deal. And then you're on the market 90 days, 95,
Sure.
I should have taken this deal, Dell's a scumbag.
Yeah. And I'm not gonna comment on that. Look, and first of all, thank you. I'm not going through every change in this purchase contract, or we'd be here all day, okay? I'm going through some of the ones that I think are more significant, but if you've got questions about any others, let's talk about them, okay?
That would be something that I could handle that would be something that I would be able to handle for you, is making sure that these little things that would be a problem for title would make sure and have those questions answered and stuff to service the clients.
But the purpose of putting the language in was to eliminate the surprise factor, right? So they knew, hey, going in, you're married, you're probably gonna need to get that signature on the disclaimer deed. And so we wanted them to know that information up front, not find out about it at the end of the transaction. All right, let's talk about the seller's property disclosure statement. The seller's property disclosure statement right now is due, how many
5
days? 5 days, and it's changing to?
3 days.
3 days. I hear a lot of agents talking about, man, this is a big change, this is a big deal. It's 2 days, okay? It's not that big a deal. In fact, we had some requests come in that wanted to make the seller's property disclosure statement a mandatory upload into the multiple listing service. There's some problems with that, and the work group wasn't willing to go that far, but they did want to shorten it from by 3 days, okay?
I love it.
Now, the reason for the change, buyer's inspection period with the elimination of warranted items is more important than ever, right? And we wanted to maximize the efficiency, the productivity of the buyer's inspection period, because we think that buyers are better able to conduct inspections with that seller's property disclosure statement in hand. And so we wanted them to have the seller's property disclosure statement in their possession for a longer period of time. Did anybody see the first draft of the purchase contract that came out and was circulated? And it had an increased time for the inspection period. You remember? 15 days. Okay. The reason that they thought about making that change of increasing the length of the inspection period from 10 days to 15 days is because in some of the outlying areas, it's difficult for them to get qualified inspectors in within that 10-day period. So we floated that out there, and it was universally despised, okay? And so we pulled back on that, but again, we wanted to do something to help the buyers. And the agreement, the ultimate end result, was to give them more time with the seller's property disclosure statement. Fair enough? Okay. All right, we talked about my least favorite portion of the purchase contract. Let's talk about what maybe, yeah, go.
Couple questions. One, the assessment liens.
Yep.
I'm a little confused because there's a lot of community facilities districts that people don't even realize.
Right.
And even the community manager doesn't realize because they're new and it was done 10 years ago or 12 or 14 years ago. So the amount of the assessment lien or bond, including those charged by special taxing districts such as a community facility district or CFD, shall be prorated as the close of escrow.
Right. So
Does that
what did
sound right to you?
and this was something that,
She's in a community facilities district and knows a lot about it, so.
okay.
The community facilities district tax is part of our property taxes.
Right.
So how do you?
In some cases, but not in all cases. And we worked with a lot of the title companies and some of the CFDs out in the West Valley to come up with this language. And the problem that we were seeing is the current draft of the purchase contract states that it has, look, who makes the offer? The buyer, right? So the buyer always fills it in, and the buyer was always indicating that, hey, this is going to be, they were always checking the box, paid in full by seller, all right? And that led to a lot of confusion, especially in regard to the CFDs, because they were taking the position that even after close of escrow, the seller had to continue paying whatever that money was owed. So sometimes they would be continuing to pay for the next 18, 19 years. And so the solution that they came up with was to say, okay, look, we're prorating it as of close of escrow. Anything up until close of escrow, that's paid by the seller. Anything after close of escrow, it's paid by the buyer. Yes?
I thought I remember reading somewhere that the community facilities district isn't necessarily an assessed amount.
It's not always.
What?
So that's another problem with this
Because sometimes it's a bond.
If it's not assessed,
Right.
then it's the way we've been
Right.
treating it, which appears.
But again, because sometimes, and that's why it indicates the amount of any assessment lien or bond. And that was the language that the CFDs had come back to us with, saying this will make it inclusive for their purposes.
Now, with regards to the seller's property disclosure statement,
Yeah.
we've started posting it right on the MLS.
Sure.
Because it's just a much handier thing. And here's the response you get. Could you send over the seller's property disclosure statement? Well, it's already posted. Oh, where is it posted? So you'll get that, but I think it's a really good idea just to post it because it just makes everything go a lot smoother, including the HOA addendums and
Yeah.
everything like that.
And there's nothing I think that's worse than when you have a seller that wants to waive the seller's property disclosure statement. Look, I will tell you, I think the seller's property disclosure statement is a great tool for the buyer, but in all honesty, that document is drafted to protect the seller, okay? Now, is the SPUDS required under Arizona law?
No.
No, okay? But law does impose certain disclosure requirements, and even if you're not using the seller's property disclosure statement, does the seller still have to fulfill those disclosure requirements? Yes. It is very hard to do that without the use of the seller's property disclosure statement. So the SPDS is really a tool that sellers can use to fulfill their obligations. And without using the SPDS, we find that most sellers are putting themselves in harm's way. Whereas they think they're somehow protecting their own interests, they're really doing the exact opposite. Is there one question back there before I move on?
Because sometimes the E&O policies require us to have SPUDs, and we actually have to disclose how many we get per transaction, and that's a hit on E&O. So I don't know, is that mandatory?
Well, we just have to use the proper forms that are available to us, the most up-to-date forms, most up-to-date contracts.
Right.
You know, on a side note, a lot of addendums are changing, probably 17 addendums are changing. So it's incumbent on us to use the most up-to-date forms for our E&O.
And I'm gonna go through some statistics in regard to improper form usage, but I'm also gonna go through the changes that are gonna take place come February 1st. So I will get there.
Like tax assessments,
Mhm.
So it's clear to know that assessment liens are not to be confused with tax liens, mechanics liens, judgment liens. This is assessments which can only be done typically by an HOA, and.
Right, because there's a difference between that and delivering clear title.
Right.
Yeah.
Right.
All right, let me move on, and I want to talk about FERPTA, okay? I don't think there's probably anyone in this room that actually likes FERPTA, all right? I understand that. But we have to include it in the purchase contract because it contains information that our buyers and sellers need to be aware of. But before I go through FERPTA, I just want to bring to your attention Realtor Code of Ethics, right? Article 11, but also the Commissioner's Rules, the Arizona Commissioner's Rules, Rule 428.1101. I know you're not have those memorized, but they both say virtually the same thing. And essentially, they prevent you from undertaking to provide a professional service outside your field of competence or your area of expertise. You know, why do I mention that now?
Because if you don't know what FERPTA is, you're in trouble.
Yeah, I mean, well, but I think that the reason I'm mentioning it is, look, how many people in here are tax attorneys or CPAs? Okay, that's kind of my point. I'm not a tax attorney, I'm not a CPA, we are not tax experts, okay? Just because FERPTA is in the purchase contract, because there's information that has to be conveyed to your buyer and seller, does not mean that you need to be FERPTA experts, all right? And we've seen issues where where agents have given tax advice and it's proved out to be incorrect. And then we've got a battle with the E&O insurance company because they're saying, well, you know, we insure you for the practice of real estate. To the extent that you're out there as a CPA or a tax attorney, I'm not so sure that that's going to fall under your coverage policy, which is not something that we want to fight, okay? But let's talk about the FERPTA language. All we did was we divided the FERPTA language into two different sections, okay? There are certain sections of the purchase contract that are more relevant to sellers, and there are certain portions of the purchase contract that are more pertinent to buyers. FERPTA, buyers and sellers have distinct obligations, and so we broke them out. Disclosure, section 4. Disclosure section is more pertinent to the sellers, and so we wanted in this section sellers to know that, hey, seller, you're agreeing to sign and deliver to the escrow company the certificate. Buyers, due diligence applies more to buyers, so we wanted buyers to know, hey, buyer, you're actually the one that's responsible for withholding the tax. We also wanted to make it clear, look, seller, buyer, you are responsible for obtaining independent legal and tax advice. So to the extent that they're asking you for information, you want to make it clear, look, guys, I'm not a tax attorney, I'm not a CPA, you got to get some independent advice, and I'm sure all of you guys have someone that you can refer them to for this information, right? Now, one thing that I just want to mention real quick is, you're going to see that this says up to 15%. What did it used to be? 10, okay? There was a change in the SAFE Act, it's been over about a year now, where we had to increase the amount of the potential maximum withholding to 15%. So I just wanted you to keep that in mind, all right? That was a change that happened about a year ago.
On 164, the word certificate.
Yes.
What is this certificate that's supposed to be signed?
Every title company does it differently. So I can't answer that question. It's a fair question, but it's one that I can't answer. You know, there is a document out there, and this may be more than you want to know, but it's called an affidavit of non-foreign status, all right? The affidavit of non-foreign status is a document that is completed by the seller and conveyed to the buyer in some instances. Now, the problem with it is you have to put either a tax identification number or a social security number on that document. How many of your sellers, a couple days into the transaction, want to provide the other party with their social security number? None, okay? And so we asked ourselves, well, okay, that's not going to work. But we knew that there were some other states out there, such as California, that were using this affidavit of non-foreign status. And so we asked the other states, I said, how is it that you're using this? How is it that you're convincing your sellers to give their social security number to buyers? And they said, we're not. There's something in the law that's called a qualified substitute, where an entity or an individual can come in and act as the qualified substitute, and they can receive that document. And in those states, the title companies have agreed under the law to act as the qualified substitute. For reasons that I understand, the title companies in Arizona didn't want to do that, okay? And so we can't use the affidavit of non-foreign status, and so we're still left with those certificates that are different that the various title companies utilize. And look, I'm not a FERPTA expert, so you may be asking me questions that I don't know the answer to, okay? Because again, I'm not a CPA and I'm not a tax attorney.
What if your seller is dual citizen, American and non-American? Does FERPTA apply?
Anyone know that answer? I don't. Go ahead.
I'm both.
Okay.
I've read, no, it doesn't apply to me.
Does not.
No, because I have.
You have an American-
I have a.
American
legal-
citizen.
Legal status in the United States. If you
Perfect.
have legal status, it should not apply, but you wanna talk to your, attorney about that. your tax-
I mean, my thought is you're filing taxes here, right?
Right.
What, well, that's not true either, because.
Wait, you're not filing
Provisions
taxes?
of the Immigration Act are required- There's other things too. So
Okay.
that statement just made is not necessarily correct.
Okay. We'll talk about it later, because I am curious about how that works. All right, let's move on to warranted items, okay?
I love it.
We talked about this before. If you're looking in the new contract for warranted items, you're not going to find them, right? We have removed warranted items. Why did we remove warranted items?
Because they're a pain in the butt.
Yeah, okay. Look, the short answer is buyers and sellers could not agree as to what was warranted. And so what they were doing is they were calling AAR and saying, well, can't you just put a list together for us of all the warranted items? They can't do that. I mean, there's hundreds and thousands of components within a home. I can't create an all-encompassing list of warranted items, and so that wasn't going to work. And then, of course, the problem was, even when the buyer and seller could agree that an item was warranted, they couldn't agree whether it was in working condition. And so we were seeing constant disputes. And going back to the theme of some of our changes, it was to eliminate ambiguity from the purchase contract. Now, I will tell you that the work group, their first thought was not to eliminate warranted items from the purchase contract, okay? They probably spent about 4 hours trying to limit the scope of warranted items and to better define warranted items in working condition. Easier said than done, all right? They simply couldn't come up with language that they felt confident enough was going to eliminate the disputes that we were seeing today. So they ended up making the decision ultimately to eliminate warranted items. Does anybody know how many other states in the country have statewide realtor contracts that have warranted items in it?
Zero.
Technically, it's 2. It's Illinois, and then Florida has one version of a purchase contract that has warranted items in it that's rarely used. But we were in the minority, okay? And that's not why we made the change. But when I was talking to the general counsels from the realtor associations in other states, it was interesting that those of them that did have warranted items, they made the change, like California made it about 10 years ago, and they made it for the exact same reason that we're making the change now. So, the language in Section 5A of your purchase contract simply indicates that the property is being conveyed in its present physical condition as of the date of contract acceptance. Present physical condition as of the date of contract acceptance. What is the difference between present physical condition and as is? Nothing. There's no difference, okay? If there is a difference, the only difference I would say is as is has a negative perception, right? A negative connotation to it, and it has the connotation that under no circumstances are repairs being made. And so, like many of the other states, we avoided using the term as is in the purchase contract to avoid that stigma, all right? So now the property is being conveyed in its present physical condition. So let's ask some questions, okay? First one is, what happens to the as is addendum now? It's gone, right? We don't need it. But it's not going away on February 1st, all right? And I'm going to need some help from you guys here as to how you're handling this, okay? It is going away on April 1st of 2017. So it's going to remain in there for 60 days. The reason is,
We have contracts out there.
not just that, but even after February 1st, it's fairly likely that you're going to get offers that come in on the 2016 version of the purchase contract. So we need to talk with your brokers to figure out, okay, that comes in on the outdated form of the purchase contract. What are you doing? What's the standard operating procedure? What are you going to do come February 3rd when you get a contract in on the 2016 version?
Don't
What do you do?
accept it.
Take it back.
Don't
Okay,
accept it.
Don't accept it. Are you obligated to convey it to your
Yes.
seller?
Yes.
Yes. If your seller wants to accept it, can they?
Yes.
Yes. So what can we do? Well, first thing we can do is we can pick up the phone, right, and we can say to them, hey, can you resubmit
Yeah,
this
rewrite it.
on the 2017 purchase contract? And I think that that's the preferred method, all right? Something else that you can do if you want, you can, in theory, counter using the 2017 version of the purchase contract. But what we heard from some of the brokers, and again, I want you guys to talk about what you're looking for your agents to do in this circumstance, but we had some agents come back and say, you know, look, the only thing we really care about and the difference between the two contracts is the warranted items. And so we want to be able to counter using the as-is addendum. And so can you please leave that as-is addendum up there for a period of 60 days so we can still utilize that to counter? So that's the reason why the as-is addendum is going away, not on February 1st, but on April 1st. So how are you guys talking to your agents about this?
So I put out a really confusing email, right, about a month ago that probably nobody
Yes.
understood.
Yes.
And I think, you know, if you keep reading it when the new contracts come into play, it'll make more sense, because it talked about if this, then this,
Okay.
if that, then this, and it just, but I think by April first, it all goes away, because.
That's the hope.
Yeah, I mean, and listen, I'm still receiving contracts for review that are dated 2014.
Isn't it a responsibility of the broker to make sure all his agent, he's laughing.
Unfortunately, it's the brokers that are the problem. No, I'm just joking, guys. But there are some brokers, right, one-man operations, that we're seeing them do it incorrectly,
You
and
just
there's
have
no
to
one
be
there to
conscious
catch
of
it.
what you're writing. I don't think that's an issue for us writing contracts. I think more is when we receive them, we just have to be cognizant of which contract we're getting it on. And listen, it's still a valid contract, no
That's
matter
right.
what year it's
That's
written on.
exactly right.
It's still valid, so you're not gonna not do your deal. You just have to be vigilant and cognizant of trying to make it, something, because like Jamie said, on the sidetrack, you know, has a bearing on that.
We have had
So,
some some brokers that have told their agents, look, put in the MLS that all offers that are conveyed need to be on the most recent version of the purchase contract, and obtain a permission, written permission from your seller that you don't have to present and can reject out of hand any contract that comes in on an outdated version of the form. I don't know that you want to go that far, but I have seen brokers giving that instruction to their agents. Okay? All right, so the next question is, well, now, it's basically an as-is contract. Does the property still need to be conveyed in substantially the same condition as on the date of contract acceptance? Yes, right? Nothing has changed in that regard. Can the buyer request repairs, even though it's basically as is? Yes, okay? Just like now, you use the as-is addendum, the buyer can still ask for repairs. Is the seller obligated to make the repairs? No, okay? Our hope is we've got a buyer that wants to buy and a seller that wants to sell, and they're gonna come to terms as to repairs that can be made. I'm optimistic that this is gonna work, okay? I think that we're all sick and tired of the problems that we've experienced with warranted items, but I will tell you that the changes that we've made to this, they're not written in stone, okay? Unlike that gravestone, I guess. If we need to tweak it, if we need to make changes, okay, we're not afraid to do that. We go back in and tweak the contract as